I am Kaitlin Atlas. I'm an attorney here at Franczek, and you are joining us today for one of our monthly 30-minute webinars. In these monthly 30-minute webinars, we try to pick a timely topic to share with you a little bit of information that we think is timely, important, and to provide you with some practical tips and tricks on a legal issue. We always try to caveat by saying this is not legal advice, and you should always ask your legal counsel about specific questions related to students. The other thing I will share is while we're all together today, I will be monitoring the chat and Q&A features. So I will keep an eye on those as we're talking today. I also appreciate everybody submitting questions ahead of time. I will try to cover as many of those as I can in our short time together today, as well as the questions you may submit throughout. The one thing I will share is that we're recording today. So to the extent you submit any questions through the chat or the Q&A feature, please keep them as hypothetical as possible. Don't use student names or specific student circumstances so that we protect student privacy. I appreciate all of you joining us today. I think we're at 44 and counting with people still joining. I know it is the last week of school for many of you, so you're busy. So thank you for joining when you're so busy. I will say, like I mentioned before, we are recording. This will be posted on our website shortly after today's presentation. So if your colleagues were not able to join us today, they are welcome to watch the recording if you found it helpful. It will also be posted on our podcast. So if people prefer to listen to it, I personally can't stand listening to myself, but perhaps others enjoy listening to me more while they're commuting or running or walking the dog. They are welcome to do that as well. So without further ado, we are going to keep today focused on 3 practical tips for navigating student matters with divorced parents. We have found in our office, as many of you know, I work on a lot of our student and special education matters in the office. One of the questions that I have been getting more and more this school year is, what do we do in these sticky situations with divorced parents? And the answer is one of my favorite legal answers to give you is often it depends. So you just logged on to this webinar probably during your lunch hour when you could have been going to Chick-fil-A or Chipotle or any of those good places just to be told it depends. Well, that's really annoying, Kaitlin. That doesn't help me at all. But I will give you a practical tip to go along with the it depends, right? The practical tip that goes along with the it depends is you want to get a copy of the parenting agreement. So we always want to get copies of relevant documents in any situation. I'm a lawyer, right? I like documentation. But especially in situations when we are dealing with a student whose parents may be divorced. The Illinois Marriage and Dissolution of Marriage Act requires parents going through a divorce or individuals going through a divorce who have children to have a parenting plan on file as part of that divorce. And the parenting plan outlines a number of parental responsibilities, many of which will be relevant to you as the student's school. For example, it requires there to be a provision that outlines each parent's right of access to school and extracurricular records, unless those records are access to those records are expressly denied by another court order. So unless there's some court order or something in the parenting agreement saying parent A or parent B cannot have those records, the parenting plan will say how each parent gets records and who has access to those records. The parenting plan will also designate which parent has the majority of parenting time. And then from there, it will designate what the split is of parenting time, who gets the student on what days. The parenting plan should also designate the residential address for school enrollment purposes. So many of your questions that came in before this, I think there were maybe 10 or 12 questions that came in that when I was reviewing them this morning and getting ready for the presentation, my answers were, It depends. Look at the parenting plan. So many of them were, if parent A and parent B are divorced and the student lives with parent A, etc., where does the student enroll? The answer depends on what is in the parenting plan. Similarly, we got a lot of questions about special education. So I'm very excited to see a lot of my special education friends in the room. And who gets to make decisions for a special education student? And the answer, once again, is, well, what is in the parenting plan? Who has educational decision-making authority? Because that will be specifically designated in the parenting plan. What we don't want is to be in a situation where we are sitting at the IEP table, or we have a parent standing in the main office telling the main office attendant, well, I think I have a right to pick up my son or daughter. And we've never seen that person before. And they're saying, no, I'm a parent. I'm absolutely a parent, but we have no idea who this person is. And they're not an Infinite Campus. And we're saying, I have no idea. And I get these calls all the time. We have this person and they're standing here and they say they're mom, but we've never seen them before. And we think the kid lives with dad, but there's this person here. What do we do? Well, I don't know who that person is, right? You're calling me, but I have no idea. This is why we really want to ask for the parenting plan before the dispute arises. Ask for it as part of your enrollment and registration process, right? Most of the time, families will give it to you. There will be some times where families say, why are you being nosy? Why do you need that document? Give them this example, right? We want to know in advance. We don't want to be in a situation where we have to call you and we are trying to parse all of this out while we have people standing in the office, or while we're at the IEP table, we're trying to figure out who signs this form, who gives us consent to evaluate, and we're bouncing back and forth. We want to know in advance. We want to keep it simple. The other thing I've seen sometimes is parents will redact or will give you only part of the parenting plan. I would much, much, much prefer that we get the full parenting plan. Again, we can explain. We're not trying to be nosy. This is not something we are sending to everybody in the district far and wide to disseminate all of your personal information. But these parenting plans have information that impacts the school district in various places. So there may be something on page 1 about student records. Then there may be something on page 32 about where the student goes on Wednesday nights. And we need to see all of that. They're not necessarily written in a way that is school district friendly, because they're not written for us. They're written for the family. So try to get these before a dispute arises as much as you can. If you ever are in that situation where you have someone you've never seen before, they're coming in, they're saying they're the parent, they claim they're on the birth certificate, we don't know who they are, they really want to pick up their kid. We don't have the parenting plan, we haven't gotten it before. We call the other parent who we do know, they say, don't let that person take my kid, I don't know who that person is. We call the police. It's okay to do that. I'm not encouraging that in the run mill of situations. We don't want to, terrify a student with the police, terrify a family with the police. But if we truly don't know who that individual is, and we're in this kind of between a rock and a hard place, and we don't have the documentation, as a last resort, we can call law enforcement to help us, and they can help pull those relevant documents. The other option before that is to ask that individual standing there, do you have a copy of your parenting agreement that we could take a look at? Because anyone in this situation should be able to pull their documents. We also want to make sure that the documents that were provided are the current documents. Parenting plans may be periodically modified, so we want to make sure the ones that we're working under are current. Most importantly, though, I see this with orders of protection. Sometimes we'll get an order of protection from a parent against another parent saying their spouse or ex-spouse can no longer be around the students, can no longer pick up the students. Oftentimes, orders of protection are granted either on an emergency basis, which are very short term, or for a year-long period. So those are short-term orders. We want to make sure we're keeping a very close eye on when those expire and following up. If you are unsure at any time, ask your legal counsel. We can easily pull the docket and see if there have been additional entries, or ask the individual who gave you the court order and say, this doesn't, this appears to be quite dated. Can you make sure this is the current order? And can you give me an updated one? Any questions on the documentation? I don't see any coming in. Practical tip, oh, I just got one coming in. What if there is no documentation? So for any family who has been divorced in Illinois since the Illinois Marriage and Dissolution of Marriage Act, IMDMA, that's a tough one for me. That's a lot of letters. They are required to have a parenting plan on file. So if it was if parents were married, they are required to have a parenting plan. So they need to have one. Now, if they were never married, they may not have a parenting plan, right? If it's two parents that just weren't married, that happens with some regularity. Then we just kind of have to work with them and figure out a way to, where is the student living? That would be the residency question. Where does the student actually sleep at night is how we're defining residency. For special education purposes, we need to kind of determine who the parent is. So who's on the birth certificate, who's acting as the parent. That gets into some sticky student specific issues. So we should probably talk about that offline for individual students. But yeah, there may be cases where there's no documentation for parents who have never been married, but for parents who have been married, there should be documentation. Is it normal for court documents to be handwritten? It depends on what they are. It's not unusual. A parenting plan probably wouldn't be handwritten because that's a fairly lengthy document. A court order, like a modification of an order of protection, standard like day-to-day court order, if you're going to county court, it's not unusual for it to be handwritten. Can parents refuse to give the parenting plan to the school? They can. We can't force them to give it to us, but we can explain why we really need it and how it puts us in a really difficult situation to not have it. And I can, if we have that situation, I would say to consult with us or with your attorneys, and we can work through how to get more information without perhaps getting the full parenting plan, or work through some agreements with that family to say, well, if you're not going to give us the parenting plan, then here is what we need to have some agreement of what we're then going to do. How do you reply to a parent that claims it was verbally agreed to with the judge and they don't have one? The judge is not going to verbally agree to something and not document it, at least in a memorandum order that goes on a docket. That's just not going to happen. So yeah, I'm gonna call their bluff on that one. That's another one I would say call your legal counsel and we can pull up the docket, but yeah, the judge is not going to make a side deal with the parent. If parenting time has been temporarily suspended, can the parent come to school to volunteer? Can they come on campus at all? I would want to see the order that suspended that parent's parenting time. The answer is most likely not, but it would depend on what the judge actually put in the court order suspending the parenting time. Usually that arises from something that happened between the parent and the student, and the judge is trying to have some separation, and they're limiting access to the student, which would mean they couldn't come near the student, which would probably mean they couldn't come to school and volunteer with the student. But again, it's going to be specific to whatever is in that particular order. So I can't say as a blanket matter, every single time they could never come to the school. Where can you go to get the most current agreement? I talked with mom and dad, and the documentation is different. The court is going to have the parenting agreement. You can look at the court docket. If you have the case number, you can pull up your county docket. Some of them will have the actual documents posted. Some counties are more advanced than others with that. So it depends on what county you're in, but at the very least, you can pull up the docket. It will say, you know, parenting order modified on May 23rd. And then you can say to the parents, I see that your parenting agreement was modified on May 23rd. I need that document. You can also ask your legal counsel. Sometimes it's easier for us to pull those documents because we have like special access to those portals. So those would be the ways you would do it. What if they are not providing the document because they just want access to the district? That's sort of a different residency question. So let's table that one for now. Do the courts provide parents with a physical document stating an order of protection has been extended? Parents typically provide this information verbally, which is sometimes questionable. Typically, you walk out of court with a physical order. Things changed during COVID, so some hearings are still virtual. With that said, you can always, if you are a plaintiff or a defendant or a respondent, etc., in a case, you can always get a copy of your own court order. We may not be able to, we as anybody off the street may not be able to get a copy of someone else's court order, but as a party in a case, they should always be able to get a copy of their court order by calling the court, by going on the online portal, etc. So while they may say, I only got it verbally, I don't have a copy, they can get a copy. They may just need to do a little work to get it. Okay. So our next practical tip is to maintain neutrality and stay student-centered. And this also kind of weaves through some of the questions that came up in the questions we received prior to today's webinar. But we really want to not take sides in these parental disputes. We want to stay factual and objective. So in general, when we have meetings, so whether it's an IEP meeting, a parent-teacher conference, just a meeting to discuss student behavior, whatever the case may be, we want to hold one meeting so parents receive the same information at the same time. Sometimes you are going to tell me, but that's going to be so awkward. I would rather not do that. And I understand it may be very awkward. However, having two meetings, what that inevitably sets us up for is two things. One is, no matter what, the parents are going to say that I got told something different. They told me that when the student comes from mom's house, they're having a really hard time. And when they come from dad's house, they're doing great, or vice versa. Inevitably, the story is going to be different. You want them to get the same information at the same time, so there cannot be a he said, she said. that is the primary reason we want to hold one meeting. The second reason is if you hold separate meetings, you will inevitably hear from the parents in separate meetings, well, the divorce has just been terrible. This is what the other spouse did. This is what the other spouse did. You want to keep yourselves out of that situation altogether. Just hold the one meeting. Yes, it may be uncomfortable to be in the room with both parents, but you will get through it. The only exception would be if there is a court order restricting you from doing so, or if there are safety concerns about having the parents be together. In those cases, consult with your legal counsel about how you should move forward with the meeting. I know there was one question that came in about an order of protection and both parents wanting to be in person. Consult with your legal counsel on those specific circumstances. There are ways to manage that. For example, virtual meetings. There's, they may want to be in person. That may not be an option given the court order. There also are times when you or your staff may be requested to be interviewed by a guardian ad litem. In most divorce cases, the children are appointed a guardian ad litem, and the guardian ad litem is someone who is appointed to advocate for the student and their best interests. So they're not really serving as an attorney for the student, they're actually serving as an attorney for the student's best interests, which is a little bit of a distinction because the student may say, I want to live with parent A because parent A always takes me out to ice cream. The guardian ad litem may say, well, yes, the student is telling me they want to live with parent A. So if I were the student's attorney, I would need to go to court and zealously advocate that they want to live with parent A. But I'm actually appointed to advocate for student A's best interest. And it's not in student A's best interest to go to get ice cream every night. So that's not what I'm going to recommend. So if you are asked to be interviewed by a guardian ad litem, number one, we need releases and proper documentation. So just because you get contacted by a guardian ad litem, make sure the appropriate documentation is in place. And number two, the biggest tip I have in those cases is to make sure we are factual and objective in those interviews. Do not take sides. The guardian ad litem may ask, so which parent do you think is a better parent? They shouldn't. I don't think that's a particularly appropriate question in those interviews, but they may ask, which parent is a better parent? Who would you choose? Who would you pick? And I think that's an appropriate time to say, I can't really speak to who's a better parent. What I can tell you is the student has been at school every day. The student sometimes exhibits behaviors, or the student has received all A's in their classes. Anything factual that you can speak to. We also want to make sure we're providing the same information to both parties. So just like we're having one meeting, we're giving them the same information. They have the same access to records. The only exception is if there is some type of order of protection that restricts one party's access to records. So if there's an order of protection that says parent B does not have access to school records, then we can't give them school records, obviously. But otherwise, they get school records, and that doesn't matter even if they don't have parental responsibility. So even if that parent B, for example, does not have any parenting time, right? They don't see the student at all. They don't have any custody rights. They still may have access to records as long as no parenting time as long as there's no court order restricting their access to records. In addition to that Marriage and Dissolution of Marriage Act, the school code also provides that when one parent requests certain records and documents, we have to provide those same records to the other parent unless there's a court order barring their access. And that's any records reflecting academic progress, any records reflecting emotional or physical health, notices of parent-teacher conferences, notices of major school-sponsored events, and copies of the school calendar. There's a question about whether a school can contact the guardian ad litem directly if there's a doubt about the parenting plan. Let's talk offline a little bit about what the doubt about the parenting plan is, but the answer would really be whether you have consent and the appropriate releases in place to communicate with that guardian ad litem. We'd want to make sure the parents have signed off on that communication. Our final practical tip, and I'm like just in time here, 12:26, it's unusual for me, is when in doubt, ask questions and seek support. I know this one sounds obvious, but these are really, really complicated legal issues. Call legal counsel. Let us help you interpret these plans. They are sometimes 30, 40, 50 pages long. And like I said before, you wouldn't believe, like sometimes there will even be a section that says school and education. Nice like little section, and you think, oh, this is the section that applies to us. I can ignore everything else. And then out of nowhere, there'll be another section that talks about school. So these are really complicated documents. Don't feel like you are in a silo. We're here to help. If you use another law firm, I can confidently speak for our partners at other law firms. They are here to help. We all are here to assist on these issues. We talked about this a little bit earlier. I'm never one for calling the police, but there may be times where these situations get very, very contentious, unfortunately. If the situation becomes so escalated that you feel that the student is unsafe, or you don't know what's going on, but you just sense something is not right, call law enforcement for support. That is what they are there for. If you don't feel safe sending the student home, if you don't know who a person is, law enforcement can help. Number one, law enforcement has access to information that lay people don't. So they can help on that front. And law enforcement can also just help de-escalate situations. So again, I'm not advocating that we call law enforcement for everyday run-of-the-mill issues. But if there are really escalated, contentious situations, that is what they are there to help with. So with that, I have saved 2 minutes for additional questions. I know there were several questions about divorced families and the intersection in the special education process. And that is a whole can of worms in and of itself. And now I'm starting to think, after seeing those questions, that maybe one of our other 30-minute webinars will be on that issue specifically, and kind of what it means to be a parent under IDEA, and navigating some of those issues. So maybe we'll do one of those in the summer at the beginning of the school year. So if that sounds interesting, you can drop a line. I will also add, while we wait for any questions, if you have any ideas about webinars, feel free to shoot me an email. We're always looking for ideas. And if you have any student-specific questions, feel free to follow up with me. I'm happy to consult offline, because I know this is a little bit of a limited forum where we can't talk about specific issues. All righty then. Well, I don't see many more questions coming in, so I hope this was helpful. I know it's only 30 minutes, so we can't address everything, but hopefully this kind of whet your appetite for more to come on navigating these issues. I hope everyone has a wonderful summer. We're at the tail end here, so enjoy your summer breaks.